everyone. Welcome back to Civil Procedure. Hope people are staying warm despite the unseasonable chill, and staying healthy and happy despite this increasingly stressful time of year. Okay, so last time we were talking about negotiation, right? Today we're going to finish up the negotiation unit and get into mediation, which we'll see follows naturally on negotiation. Because it's mediation is effectively just assisted negotiation, right? And we're also going to watch a video of a mediation, a realistic simulated mediation, to give a sense of what goes on inside that room and what mediators actually get up to. I think we'll do these participation questions mostly as we go. This one maybe we should talk about, this Tweedledum business here. So this is all about the different terms that are used when we're talking about positional negotiation, right? Positional negotiations being those in which the parties are typically just trying to divide some fixed and finite pool of resources, or at least they act like they are, right? So, positional negotiation is to some extent a style. It's a way of approaching mediations and negotiations as if you're trying to get a bigger slice of the pie, as opposed to trying to grow the pie. And we talked last time about some of the strategies that come from that positional approach to negotiation. But these terms are always worth thinking about when you go into a negotiation of any kind. So we've got these two, and there's a claim, right? There's a statement of claim. This is a civil litigation, right? Tweedledee is sued, claiming that your client broke this doohickey, and he's claimed $30. So that's going to be the damages claim, be the $30. That was the original piece. Now, the interesting thing about negotiation is all of those claims that are made in the statement of claim kind of lose a lot of their significance, right? If you're negotiating to settle your civil legal dispute, you, as the plaintiff, can completely abandon everything you asked for in the statement of claim. There's no law saying that you have to, insist on getting any part of those things. Likewise, if you're the defendant, you are not bound by your statement of defense when it comes to your negotiating position. Facts may have changed, your bottom line may have evolved. You are free to strike the deal that works best for your client and that minimizes your client's risk. So $30 would be the damages claim, and then you've got your client instructing you here about what position to take. So first thing you do when you go in there, ask if the other side will settle for $9. So that would be the opening offer, right? And we talked about the tactic of concealing your resistance point and starting sometimes with an aggressive opening offer, so that you have room to compromise while still remaining within a favorable range for your client. But $9 would be the opening offer here. But then when he says, I'll pay up to $15 to make this nightmare go away, that's his resistance point. If you are on for a defendant, then the resistance point is the most you would be willing to pay in order to settle a lawsuit. What's the resistance point for a plaintiff? So it's the least they would be willing to accept in a settlement. Okay, so hopefully those terms are clear enough to people. Okay, and then I gave you this question down here, and people, I think, got all of these, right? The tactics, these were all discussed in Adams. We looked at a slide on these yesterday. The very kind of things you would do if you were negotiating over money in some other context. And all of these things can succeed in the right case, but they can also be potentially quite dangerous. The contract zone. I didn't talk about that. So the contract zone is defined as the distance between the resistance points of the two parties. So the distance between the least amount that the plaintiff would accept and the largest amount that the defendant would be willing to pay. And if those are the true resistance points of the parties, then by definition, whatever number they agree on will be in that contract zone. So here we don't actually know what Tweedledum's resistance point is, but it has to be $12 to $15 has to be the contract zone, because the other numbers in the options were all corresponded to one of these other things, and it's the only one of those options that was actually a zone, right? 12 to 15. So in this case, that's going to be, we can assume now that the $12 is the least that Tweedledee would accept, the least that the plaintiff would accept in order to resolve that dispute. So assuming nothing else comes up and they can't invent any other intelligent solutions other than the payment of money, and they do settle, they're going to settle for a number between $12 and $15. Another thing that Adams mentions is this idea of that in litigation, parties are driven to take inconsistent and diametrically opposed positions on factual disputes, right? But he talks at page 14 about how when you're negotiating a resolution, you can bypass a contested factual proposition and determine whether a settlement can be reached if its truth or falsity is held in abeyance. Okay, so all of a sudden, we are not trapped on this number line anymore, right? We're not in this sort of two-dimensional battle for money. We are in a more three-dimensional space where creative solutions are possible, which maybe respond to the interests of all parties better than a simple number on a check ever could. So this is now interest-based or integrative bargaining, right? Which is the second of those two major schools that George Adams talked about in the excerpt you read. And there's two big ideas in interest-based bargaining. The first, wait for it, is growing the pie, right? Which is what you were all just doing when you were thinking about new things that can be done, which perhaps respond to the interests of both parties. So if the pie gets bigger, then everyone gets to have more pie, and the size of my slice is not coming out of your slice. So this happens in lots of different ways, right? It can include things we're talking about that work for both. The pie is also growing if you can come up with an inventive solution which is advantageous for one party while being simply neutral for the other. So a classic example there is tax structuring a settlement. So if you're in the type of case where the defendant's going to be paying a bunch of money to the plaintiff in the settlement, if that money is paid in a certain form or with a certain structure, then it will be treated as income by the Canada Revenue Agency. And your client, the plaintiff, will have to pay income tax on that money. Whereas if it's structured in a different way, or if it's described in a different way, then it will not be income for your client for tax purposes, and your client won't have to pay tax on it. So if you come up with that structure, I mean, the loser is the Canada Revenue Agency, but your client wins and the defendant doesn't lose anything, because it doesn't cost them anything to do that. So either everyone can get a larger slice, or your client can get a larger slice without shrinking the other side's slice of the pie. Okay, so the other big idea here is the distinction between interests and positions. Okay, so positions are claims about the law or claims about facts, including claims about damages that your client has suffered, right? Statements of claim, statements of defense, all pleadings are basically legal positions. Interests are what a party really wants. So the idea here is that whatever you might have written in your statement of claim will not necessarily correspond exactly to what your party wants, because interests are sort of deeper-seated psychological or economic desires that your client has. And then through the process of drafting pleadings, you take those and you translate them into legally defensible positions which serve your client's interests as well as possible. but the distinction remains between positions and interests. So one of the participation questions got to this. Whoops. The question about Fareed. Yeah, so Pat and Jan are parents of Fareed. They're divorcing and struggling to agree on a parenting arrangement for Fareed. They both want sole custody. So sole custody, you know, in family law means that you are the only parent who is making decisions about that child's education, and you're almost certainly the parent who spends with whom the child is living most of the time. And both these parents want that, and the right to control the other party's access to the child. So under this interest-based bargaining theory, you would be looking for what those interests are. And the ones I was looking for that looks like most people got are these two things in here, right? So these are the reasons why the parties want sole custody, not the reasons why they think they're entitled to it in the sense of, you know, what the precedents say or what the legal test for a custody and access order is, but rather what's going on in your client's head that makes them want this, right? And in a family law dispute, you know, these type of things are very common, right? When you have a high conflict adversarial divorce, parents are often driven by fear of being sidelined or losing touch with their child. And of course, you know, they're also motivated. It's not that an interest doesn't have to be selfish. It can also be an altruistic something, right? Like desire to provide a stable home for Fareed, looking out for the child's best interests. Okay, so in interest-based or integrative bargaining, the idea is that if you can understand the party's interests, which are often concealed, but if you can kind of dive down and access them, they are more likely to overlap. That's why that's why we use the triangles, right? Or, you know, George Adams used this. I just copied it in the book. But the interests are more likely to have an overlap than the positions are, because, you know, with Fareed, it's impossible, it's legally impossible for two parties to have sole custody. So there is no overlap whatsoever between their legal positions. But desire to provide a stable home for Fareed, right? That's something which they share. And you know, if both of them want to avoid losing touch, and if both of them want to avoid being sidelined as a parent, then that again is something that that can be reconciled. So some type of creative resolution, whether it's shared custody or some type of, you know, there's 1,000 different creative things you can do in family law, may be able to serve the interest of both parties at once. Okay, so we've talked about these two modes of bargaining, right? Positional or distributive bargaining on the one hand, and then interest-based or integrative bargaining on the other. So let me ask you, what type of situations, what type of legal disputes lend themselves more to one of these as opposed to the other? What sort of disputes or what areas of law or types of claim are more likely to call for positional or distributive bargaining, which is where we had our number line, right? Okay, so yeah, personal injury is a great example, right? Because in personal injury, you are the resolution is going to be purely monetary almost all the time. And another characteristic, what else about personal injury lends itself to positional or distributive bargaining? If you're on for the plaintiff, right, a personal injury plaintiff, why is it that you're not going to spend that much time thinking about this? No relationship between people. Well, I mean, there's a relationship, but the relationship is created only by the litigation and by the fact of the insurance policy, right? The parties will go their separate ways. So positional bargaining tends to happen when the parties are going to be strangers afterwards. Interest-based bargaining is far more important when there is some chance of an ongoing relationship between the parties, right? So co-parents, people who have a child together, I mean, they're not going to be strangers. If you've got a child with someone that's a 4-year-old child, you're going to have some type of, or ideally, except in the worst high conflict situations, there's going to be some type of ongoing communication between you and that other parent while the child remains below the age of majority. So interest-based integrative bargaining is more likely when there's an ongoing relationship going forward. And some other good ideas here. So the fact that it's an insurer on the other side is also relevant insofar as they really don't have the power to do anything to, like, you know what their interest is, right? Basically, the interest in the insurance party is to minimize their payout and perhaps to avoid creating negative precedents that will hurt them when they're negotiating future cases. So there aren't the number of interests below the surface are not that rich there. So sometimes these things are described as styles, right? You'll hear that someone, lawyer X is a very positional, hard-nosed bargainer, and lawyer Y is very interest-based or integrative. My view is that it's a mistake to adopt either of these things as your style that you will apply to every case. Because I think that especially if you're working in different areas of law, you need to have both of these, both types of arrow in your quiver, right? That means, first of all, that you need to know what kind of case you're dealing with, so you know which one to emphasize, but also that every case has room for both of these, right? Like even the most sort of collaborative, interest-based, grow the pie type scenario, your client still has positional opportunities and positional risks, right? Because on one level, no matter how big you can make this pie, you still want to go away with it as much as possible. And on the other hand, even in a case which is very distributive and very positional, there is always one interest that both parties share. And what's that? Even if it seems like there's nothing at all that you have in common, there's one thing that both parties share. Avoiding litigation. That's right. And ending litigation as soon as possible, saving all those time, stress, and money costs of litigation. So however hard-nosed and positional you want to be, you need to be. That's something that you're pursuing along with the other party. Okay. So Adams talks about a lot of interesting kind of dimensions about how these things interact. Right. He talks about this negotiator's dilemma idea, whereby if the things you do to try to generate new solutions and grow the pie can also be things that undermine your client's position in terms of the distributive piece, because you have to reveal things. So different ways to handle that tension. And another idea that he talks about that's I think interesting is as a way to that's negotiator's dilemma. But he talks about this opportunity to preserve both the opportunity to grow the pie and the opportunity to maximize your slice, and that is this use of phases. So on page 44, he talks about how negotiation will often go through these phases, where there's a differentiation phase, which is followed by an integration phase, which culminates in an agreement. So in the differentiation phase, this is where the parties are stating their positions, asserting their positions, providing legal position. They may be bluffing, they may be threatening the other side in different ways. And they're trying to conceal, the party is trying to conceal its own resistance point while detecting, if at all possible, the resistance point of its adversary. That will often be followed sequentially by an integration phase in which the parties come to perceive their common goals, at very least their common goal in avoiding litigation, and hopefully some deeper interests which may unite them and may create opportunities to grow the pie. And once that happens and sort of ideas are generated, then the agreement will follow. So, no question that while you need both of these arrows in your quiver, you need to we also have to recognize that different personalities respond to these things in different ways, right? When it comes to differentiation and positional bargaining, some people really thrive on that; they love it. My father is one of them for some reason. Great guy, but he loves to. He loves just the thrill of taking a position and arguing for it. But other people find it very tedious, especially to the extent that there's bluffing involved, or you have to kind of put on an act. People don't like that at all. You've probably maybe dipped into this a little bit, or got a sense of this in the practice simulation last year when you were negotiating. Hopefully, people remember that sense of how these things happen in a negotiation. But one of the things that Adam says, which I think is quite compelling, is that the integration phase and the subsequent agreement are in many cases impossible unless differentiation has occurred, right? That no matter how collaborative you are and no matter how many opportunities you see to grow the pie, if you walk into a negotiation and you don't spend some time doing this, then these things cannot happen. Right, and that's for a couple of reasons. One of them has to do with the fact that this is representative negotiation, right? So your client will often either be there in the room with you or in communication with you, and clients look to lawyers as their champions, right? They look to lawyers as people fight on their behalf. And your client will often need to see you fighting on their behalf and asserting your position in a compelling way before your client will be psychologically prepared to accept compromise. And if they don't see you doing that, then they're just not going to bite when it comes time to have that difficult conversation and ask them to moderate their demands and come to the middle. So even if lawyers aren't involved, even if it's self-represented litigants, or even if your client is sort of giving you carte blanche to settle, the lawyers themselves may not feel that they're able to make those concessions, and for good reason, unless they have differentiated first, because the suspicion will be that you're leaving too much on the table, and your client's slice of the pie will be minuscule unless you have clearly asserted the basis for the claim you brought in the first place. Okay, so differentiation may be necessary, but if the differentiation phase is too hostile or generates too many negative emotions, then it may make it impossible for the subsequent phases to occur. So these are things that you kind of feel in your bones after you've done a few negotiations, but you may find that this theoretical matrix is helpful for understanding what's happening in the room when people are trying to negotiate to resolve a legal dispute. Not restricted to civil disputes either. I mean, pretty much the same phenomena will occur if you're negotiating a criminal matter, negotiating a plea bargain with the Crown, for example. Okay, unless there's any questions on that, let's talk about mediation. Right. So far we've been sort of thinking about negotiation. Mediation is effectively a form of assisted negotiation, right? So a mediator has to be as a neutral third party who will assist the parties in seeking a voluntary resolution, but without having the authority to impose one. That's what distinguishes a mediator from an arbitrator. Arbitrators do have the right to impose a resolution on the parties. A mediator doesn't. So mediation is very, very common in civil litigation, especially in some practice areas. In Toronto estate litigation, for example, it's the absolutely standard way for cases to resolve. Also very common in personal injury. Less common in some forms of intellectual property and corporate litigation, but very much a main tool in the arsenal of every civil litigator nowadays. So negotiation versus mediation, kind of just trying to decide between these. Mediation, we'll talk about its advantages. But before we do that, mediation also has some drawbacks. Like there's some advantages which old-fashioned bilateral negotiation has relative to mediation. Can anyone identify one or two of those for us? Sure, the cost of a mediator. Mediators do not work for free. They have to be paid. Some of them are quite expensive. George Adams, who wrote the book, is $10 a day, as I recall. Not cheap. So it's so negotiation is cheaper. It's also more flexible, right? You can you can negotiate a case by just picking up the phone and phoning the lawyer on the other side, right? A mediation has to be scheduled. You got to find, it's actually, a depressingly large portion of your day when you're a civil litigator is trying to schedule things, like find a time when the mediator and all the clients and all the parties are available on the same day at the same time in the same place, right? So that takes time and effort, negotiation, pick up the phone, hash it out with the other side. So some old school litigants say, why don't we just do it that way instead of having to go through this process? And it's also flexible, of course, right? You can negotiate by email, over the phone, and so forth. But that being said, there's an enormous number of cases which cannot settle or will not settle through bilateral negotiation, which are successfully resolved through mediation, right? It's proven to settle cases that don't settle otherwise, and that's why it's becoming mandatory in our system. Okay, so before we get to actually looking at a mediation, I should maybe talk a bit about this case, Olivieri versus Sherman, which was in your readings, which is about a mediation and sort of illustrates how a mediation can unfold, and also is a good review of some of the stuff we learned about the contract law of settlement. So this was an intellectual property dispute and a dispute about an employment and funding relationship. We don't really have time to get through all the facts, but it was a dispute which wound up in mediation. George Adams actually was the mediator in this case, same guy who wrote the book. And so they had this mediation on November 2nd, 2004. They had a single session at the beginning where they were all together, right? So both clients and their lawyers were all together in one room, kind of talking about their interests, and good old George was introducing them to the process. After that, they separated into 3 rooms, right? So one room with Nancy Olivieri and her lawyer, and then one room with Barry Sherman and his lawyer, and then the lawyer sort of in the middle. Oh, sorry, the third room was for the CBC defendants, who we don't really need to worry about. And then the mediator, George Adams, conducted shuttle diplomacy, going back and forth, right? So shuttle mediation is where the parties are not in a room together. The mediator goes back and forth between them, delivering messages, right? And so what was he doing? What would a mediator actually do? Well, there's two things that a mediator can do in a mediation, roughly speaking. The first thing is facilitative mediation. So in facilitative mediation, the mediator is trying to help the parties identify their common interests. So facilitative mediation is in line with this, right? With the interest-based dispute resolution. And the facilitative mediator there has a relatively small role, and insofar as they're primarily just there to facilitate communication between the parties. And the parties themselves, in facilitated mediation, generate the solutions. So that's why on this slide, the mediator is relatively small, because the parties are the source of the solutions. And in facilitated mediation, the joint session where everyone's together in one room tends to predominate, because it's only when the adversaries are looking each other in the eye, the idea is that it's only then that they can communicate and undergo that process of understanding their shared interests. The second model of mediation is evaluative mediation. So here, the mediator has a much more prominent role. So an evaluative mediator is going to be predicting adjudicated outcomes. An evaluative mediator will almost always be some type of legal authority figure, like either a highly experienced lawyer or often a retired judge will do this work. And an evaluative mediator is going to be telling the parties what a judge might do if it actually gets that far. So in evaluative mediation, this caucus format is far more common. In evaluative mediation, the parties will very often be in separate rooms, and the mediator will go back and forth between them. And a lot of what they do, a lot of what the mediator does, comes down to throwing cold water, which is to say, telling each side why their case is not as strong as they think it is, and why they really better think about making some concessions, otherwise they stand a serious risk of going to trial and getting royally screwed. So to do that work, that throwing cold water work, you can't have everyone together in one room, right? Because if Olivieri and Barry Sherman are at each other's throats and they're all together, and the mediator is telling Barry Sherman all the reasons why he might lose and why his case isn't as good as he thinks he is, then Olivieri is listening to that going, yep, that's right. Yes, all of that is true. So screw you, Barry, right? So that's not going to work because you're going to make her feel stronger at the same time you're making him feel weaker. An evaluative mediator wants to make them both feel weaker so that they both come towards the center and moderate the resistance points, creating room for negotiated resolution. Okay, so we've got these two kind of things that go on in mediation. Again, just like with the sort of styles of negotiation, different mediators will kind of be identified as having a facilitative style or having an evaluative style, but the very best mediators are able to do both these things. They have a command of the law, so they can actually make those predictions, because we've talked already about how people are always negotiating in the shadow of the law and are always trying to take positions with an expectation of what might happen if they do end up before a judge. So an evaluative mediator will know that and make those predictions, but at the same time have the facilitative capacity to let the parties communicate and generate their own solutions. Because the parties will always be the experts on their own interests, and no evaluative mediator can tell parties what their interests are. They can simply, the best they can do is help them communicate about that with each other. So the parties, yes, can decide what kind of mediator they want. So if the parties are represented by lawyers, then the lawyers will typically recommend a mediator, and a good lawyer will. So like mediators won't put this on their webpage or their business card, right? I'm a facilitative mediator. I'm an evaluative mediator. The lawyers will simply know the style of the mediator from prior experience. And then they'll recommend one to their client, hopefully based on the characteristics of the case, because it's all about trying to advance your client's interest through a negotiated settlement. Okay, so coming back to Olivieri versus Sherman, we've got George Adams doing the mediation, doing some combination of facilitative and evaluative stuff. It was a long and exhausting process, right? So they met all day, and then at the very end of the day, they met all day on November 2nd, and they came back. How would they resolve differences? Okay, so Jessica asked an interesting question. If the two sides prefer different mediators, they would have to keep on going down the list until they find one they can both agree on. When we get to mandatory mediation, Rule 24.1, we'll see there's a court process where it's a Rule 24.1 mandatory mediation. But most mediations are undertaken voluntarily by the parties. So they would just have to keep on thinking about it until they come up with one they agree with. And if they can't, then they wouldn't be able to mediate unless and until a court forces them to under Rule 24.1. Okay, so November 2nd they met. They negotiated all day. Then November 3rd they came back for day 2 of the mediation. So Nancy Olivieri made some settlement offers on day 1. Sherman and Apotex made counteroffers on day 2. So Sherman and Apotek's offers were handwritten, right? They had these 3 big pages of flip chart paper, and we see some of the terms there in the case. Terms don't really matter, but they're going to drop their lawsuit. There's going to be mutual expressions of regret. They're each going to apologize to the other side and make certain statements. By the conclusion of the mediation on November 3rd, Dr. Olivieri had not accepted the counteroffer. Okay, so day 2 of the mediation ends. There's an offer from Sherman on the table. Olivieri has not accepted it because she needs to consult with a third party about who's going to pay her legal fees. But the term of Sherman's offer seemed to suggest that she had 48 hours to accept it, so it would remain open for 48 hours. So she goes away. The next day she decides she does in fact want to accept the offer. And her lawyer tries to communicate in several different ways that he wants to accept this settlement offer. The response is deafening silence from the Sherman Apotek's camp. Now in contract law, that should not be a problem, right? A contract requires only offer and acceptance, not offer and acceptance and then confirmation of acceptance from the offerer. So if Sherman offered and she accepted, then that's a contract, even if they say nothing further afterwards. So Olivieri thinks they have an agreement. A year goes by because the terms were such that nothing had to be done right away. She reaches agreement with someone else. She says, okay, let's carry this out. I'm going to publish my apology. You publish your apology. Let's do this settlement deal that she thinks we have. And she brings a motion to enforce it. It's important to note here, you can bring a motion to enforce a settlement agreement, just like you can bring a motion to enforce a judgment. And Apotek says, we have no settlement. Okay, so Apotek's view is that this this flip chart that they presented to her is not a settlement offer because it's too vague. Sorry, I've just lost all my notes. Okay, so they say what we had was not a settlement agreement because of certain things which were vague, right? It didn't specify the exact words of the apology. It didn't say when exactly we were going to do these things. So basically, it didn't qualify as an offer. And they go to so the motion judge agrees with Apotek's, and they say, look, this was not an offer and acceptance, and therefore there's no contract. The delay is part of Sherman and Apotek's case, right? We said earlier that obtaining the immediate benefits of settlement is one of the things that makes settlement advantageous. So it's unusual that a year would have gone by. And Apotek says, well, that proves there was no actual meeting of the minds on this. Sherman and Apotek also point to the certain vague language in this, what they say was not actually a settlement offer. Like it said, the parties are only going to express their future views in a scientific forum. Because they had a dispute over this drug and whether this drug was actually dangerous or not. And the flip chart said the parties are only to express future views about deferoprone, this drug, in a scientific format, right? In a scientific forum. So Sherman says, well, what's a scientific forum? We don't know what that is. That's too vague to constitute a true agreement. Okay, so the motion judge sides with Sherman and Apotek's. The Court of Appeal reverses. They side with Olivieri, saying that there is, in fact, a settlement agreement. So at paragraph 41, they emphasize that a settlement agreement is a contract. The normal law of contracts applies. And it's whether or not a contract exists is not a matter of subjective intention, right? The real question is about whether the essential terms are present in both the offer and acceptance. And you don't have, when you've got a document and you've got sort of the conduct of the parties you can examine, then there's no need to look into the parties' heads and examine what they were thinking at the time. This is paragraph 44. Determination as to whether a concluded agreement exists does not depend on an inquiry into the actual state of mind of one of the parties or the evidence of one party's subjective intention. It can be measured by an objective reading of the language. Nothing in the counteroffer, paragraph 46 now, either directly or indirectly suggests that its terms are subject to further elaboration, documentation, or agreement. Right? So it wouldn't be a real offer that she could accept if it said, we'll do this if something else happens. And it wouldn't be an offer if there was no way to see anything that the parties were both agreeing on. But the mere fact that a term in that offer might lead to a dispute later does not in of itself change the fact that the parties agreed to it. Right? So the offer said the parties will express their opinions about deferoprone only in a scientific forum. Yes, that could lead to a disagreement. That could lead to future litigation. There's room for debate about what that means, but the parties can still agree on exactly that. And it still counts as an offer, an acceptance, and a contract. Okay, so far this sounds like it could be the kind of contract case you would have read in your contracts text. But the court also emphasizes at paragraph 50 that the policy of courts is to encourage the settlement of litigation, right? Which might make a difference here, insofar as courts might be a little bit quicker to find a contract and to enforce that contract when it's a contract to settle litigation, given the policy we already know about of encouraging that. Okay, so those are kind of the legal takeaways. Contract law applies. It's based on the document, not based on subjective intent. But as far as like the moral of the story or the litigation strategy piece here, is that it's very unfortunate that they had to go all the way up to the Court of Appeal just to decide whether they had a settlement agreement or not. And if you reach a settlement in a mediation or a negotiation, it's very valuable to move quickly to litigation-proof it, right? To ensure that all parties are on the same page and there is as little room as possible to wiggle out of it, right? To actually hammer down those ambiguities and make sure everyone knows that we have a meeting of minds. Which can also be very challenging, right? Especially since these mediations often go into absurd hours of the night, right? Like midnight or later. Sometimes because there's a lot of things to talk about and hash out, but also because, if you've got parties who are reluctant to make concessions, mediators find that one of the things that's most likely to get them to make concessions is just like desperation to be done with it, right? And hunger and fatigue, and belief that the only way to get out of the room and get home and get something to eat, well, I mean, generally they're fed, but they want to get out of there. It's awful being in one of these things for 12 hours. But it's not until there's a certain sense of fatigue and desperation sets in that the parties become willing to entertain concessions that they would considered unthinkable at 9 in the morning. So if it is that type of negotiation that's gone late, as these ones did, and you think you've got a deal, it's hard to put your mind to reducing it all to writing and getting it all squared away so there's no room for disagreement. But it's worth it because it can save you a lot of time and aggravation, and avoid this type of dispute about whether a settlement even exists. Okay, so I think we can now move on. I think let's talk about the mandatory mediation on Tuesday. But let's talk about let's look at this simulated mediation video, which shows what actually happens in a typical sort of mediation. Okay, it's this one here, and it's based on an intellectual property dispute, right? A patent infringement case. So Gigem, these guys over here, are the plaintiffs who are now the respondents, because there was a lower level judgment in favor of the plaintiffs, which was then appealed by the defendants. So Gigem are the plaintiffs and the respondents, and Miko on the other side. So this guy named Luke Brandt left GIGEM and went to MECO. He was an employee of GIGEM. He departed and became an employee of MECO. And the allegation is that he took certain trade secrets, certain like confidential intellectual property from GIGEM and brought it over to MECO, and MECO is now using that information to create a product which infringes on GIGEM's patent. A common fact situation in intellectual property disputes. Okay, so on each side, you'll see there's a senior executive from the company as well as the lawyer for that company. And as I said, there was a trial judgment. So the trial judgment found that MECO over here infringed on GIGEM's patents. And the trial judge ordered MECO to pay $9 million in damages to GIGEM. MECO was going to appeal that ruling. But they've now agreed to mediate to try to avoid the necessity for the appeal, right? People remember you can settle an appeal, the same way you can settle anything else. So these parties would have exchanged mediation briefs where they basically lay out their positions, kind of like a pleading for a mediation, and given those to the mediator, this lady in the middle here. So it's a Dutch production, so there's some Dutch accents going on, which you'll get used to hopefully, and there's also Dutch subtitles for the Dutch readers among us. Yeah, so I'm going to try to make this work here. I think we'll watch this for about 30 or 40 minutes. But okay, as you're watching, think about what value the mediator adds, and maybe if you come up with something, like just maybe throw it up in the comments, right? Like what is the mediator doing for these parties that they could not have done alone, right? If they were just trying to do a bilateral negotiation with the parties and the lawyers, what has the mediator brought to the table, extra value add? And also think about look for a turning point. At what point do they turn from the differentiation phase to the integration phase, as we described those two concepts? Okay.
Good morning. I am Manon Schoonwille, the result to be mediator you have chosen. And you are?
Mijn naam is Karl Schmid. Ik ben CEO of GIGEM AG aus Berlin, Germany. And we are a world leader in chemical products and the owner of Bind It For All, which we call most time B particles, and which is a patent product.
Morning, my name is Alexandra Friedman. I'm an outside lawyer and I represent GIGEM AG in this case.
Peter McDermott, CEO of MECO Inc., the Canadian producer and distributor of a specialty chemical product called N Particles. We are based in Ontario and market leader in USA and Canada.
And I'm Chris Powell, the General Counsel for MECO.
Okay, well, thank you. Are you comfortable with using first names?
Sure.
Okay. Well, from my exchanges with both lawyers and mediation briefs, I know that you come here well prepared and that you know what to expect from the mediation process. However, I would like to say a few words about my role and also about mediation. My task here is to help you find a negotiated solution to which you both can say yes. I am not here to judge who is right or wrong. I will also not take sides, and I will not impose any solution on you. What we want to do here today is to find a negotiated outcome that is beneficial to both of you. Now, mediation is voluntary, as you know, but it asks commitment. It asks commitment to work hard. It asks commitment to take difficult decisions. And it asks commitment to look at things from different perspectives. Now, I'm ready to do whatever I can to help you find a negotiated outcome. The question is, are you ready to do that too? Okay. Thank you. Now, a few more words regarding the process. Mediation offers privacy and confidentiality, meaning that if your dispute would move outside of this room, you cannot use what you learned here or any information acquired here in subsequent proceedings. Also, at some point, it may be useful for us to split up on separate meetings. And if you give me any information during this caucus meeting, I will not convey it to the other side unless you would expressly permit me to do so. Well, we've discussed this before our meeting. It has been laid down in the mediation agreement, but I just wanted to point these important things out. Just a couple of more things to check. You have full authority to make binding decisions here today?
Yeah, sure.
Okay. We are all available until 3 o'clock.
Yeah.
Good. Do you have any questions at this point?
Yeah.
Okay, so I would say we are ready to begin. Who would like to start with the first opening statement?
As we initiated mediation, I really would appreciate if we could start.
Well, we know we'll have the opportunity to go and make our opening statement, so yes, please, go ahead.
Thank you. We do welcome this opportunity to try to settle this dispute in a way that makes sense for both parties.
Gigan's lawyer focuses her opening statement on its position that Miko has infringed Gigan's patent, which is also what the trial judge found, and therefore Miko owes 9 million Canadian dollars. She assumes that Miko will appeal the Canadian court's decision. She enlists the mediator's assistance to help the parties communicate better and stresses that although they have a strong legal position, they want to try to settle the case. When concluding, she invites her client to say a few words to Miko's CEO.
Peter, I appreciate that you are here to try to settle this dispute.
Gigam's CEO expresses his anger due to Miko selling products containing Gigam's patented substance, and Miko gaining access by hiring a former Gigam employee, Luke Brand. Through massive sales by Miko in Canada and shipments to the US and other countries, Gigan's business has been damaged. He is also upset that Miko did not try to settle this dispute much earlier. He stresses that he hopes that Miko is open to hearing Gigam's point of view and that Gigam is open to hearing new information.
Yet, we are here, trying to and willing to mediate. We hope that you can appreciate and understand our view, although we are open to hearing any new information and are ready to find a fresh way to resolve this dispute as soon as possible, of course with the help of the mediator.
And we also have a number of clarifying questions we want to ask about Luke Brand to ensure he's not disclosing our confidential information.
Okay, thank you. Peter and Chris, may I ask you not to react yet to what you just heard, but just deliver your own opening statement first?
We also welcome this opportunity to try and resolve this matter, and in the interests of both of our companies. We do, however, vigorously contest the Canadian court's decision. And in fact, we've already prepared an appeal to be filed tomorrow. Plus, we have some new information for you that you are not aware of. We have in fact found a prior publication from China that was published before the application date of your own patent. This now actually becomes prior art that we believe invalidates your product claim. Now, as far as the process claim issue is concerned, we deny infringement, and we think that the trial court made a material error of law. For us, it's very simple. A 9-step process to achieve a product cannot be the same as a 7-step process to achieve a product, especially when the order of the steps is different, which is the case for us here. Also, we feel our reputation's been damaged by your own behavior. We noticed that as soon as the verdict came out in the Canadian court, you sent a mass mailing, kind of a press release to all of our customers, and they have already canceled orders with us. This is before the injunction is in effect, and the judgment is not yet public notice. And so we will be counterclaiming against you 1 million Canadian dollars in damages. Look, we can go into the legal details later on, and I'm ready to do so. I think, though, Manon, that the point is, we would like you to help us to resolve this dispute, and we'd like you, in particular, to help us in a way to get away from positions and help us explore options that we've not been able to do on our own until now. And the next thing is, I think it's most important. Peter has something to say to Carl. So, Peter, why don't you speak?
I would like to thank you for finding the time here today to try to settle this dispute. It should come as no surprise to you that we too are very angry and convinced that we have not infringed on your patents. We respect intellectual property and have filed for our patent application ourselves to our end particle technology that will be published soon. We independently developed our formula by designing around the information contained in your published patent design. And we were not assisted by your former colleague, Luke Grant. And although end particle and binded for all may serve similar needs, end particle is a far better product, based on a stable formula, and it's faster and cheaper to manufacture. We are an ethical company with an excellent product, and we treasure our fine reputation, which you have damaged. We want to settle this case instead of wasting more time and energy and money on litigation, meaning that we hope to find a creative solution today.
Okay, well, I heard you say that this is the first time that both sides have had the chance to directly communicate about the issues that have arisen between you. I also heard that you want to resolve this case. I heard that time is of the essence and that costs are an issue. Moreover, you enlist my help to facilitate communication between you and also to find creative solutions. I would like to make a list of issues for a negotiation agenda, and I would welcome you to add or change where appropriate.
Okay.
Now, based on the opening statements and what I heard thus far, the issues are whether end particle products infringe GIGAM's product claim and its validity. I heard an issue about infringement of GIGAM's process claim. We spoke about MICO's appeal and the counterclaim. Confidentiality issues regarding Luke Brand. Preserving the reputation of each company, and searching for creative solutions. Is this accurate, and will we cover all?
We also need to discuss how MICO will pay us for infringing our patent. We've been awarded $9 million, and we are willing to be flexible on payment terms.
Alexandra, if we're heading in that direction, this is going to be a very, very short day. We are confident that the Court of Appeals is going to find in our favor. And as I said earlier, our appeal is ready to be filed tomorrow, and we think we have a very strong case for 1 million Canadian dollars in damages against you. So if you think that there's money to be paid, we actually think will be due to us. So sure, let's put the word compensation down on the list, but Manon, we think that means there's money due to us. So please go ahead and put the word down.
Okay, so we need to discuss compensation, right? Okay, so what would you think if we would first consider confidentiality and Luke Brand and what happened with the product claim and process claim, and also the impact it had on the reputations of both companies? Okay, good. Carl, can you tell me about the development of end particles and its relation to the product from your perspective?
Well, MICO has taken advantage of our work by hiring our former employee Luc Brandt, who has access to all confidential information regarding B particles.
Carl, I'd just like to point out that there is no confidentiality clause, nor is there even an anti-competition clause in Luc Brandt's contracts with Gigem. If you felt so strongly about it, I'm surprised that you didn't put in a clause in this sort in his termination agreement. It's something I would have thought your company would have taken care of if you wanted to impose any restraints on him. But more importantly, I want to stress to you once again, Luc Brandt has not been involved in any of the developments within MICO. We based ourselves on publicly available information, and we simply designed around your patent application. You should also remember that the Canadian court dismissed your trade secret claim. So we really don't think that there's any reason for concern with respect to Luc Brandt.
The fact is that Luc knew about the IDs and formulae that leading to the development of binding for all. And he also had access to classified information before starting to work for MICO. Whether or not Luc had clauses in his contract is irrelevant.
Okay, Carl, can you please continue to explain, and obviously you will get the same chance in a moment.
Yes, during an exhibition in Dubai, we learned that MICO is selling this substance called N particles, which is claimed to have the same abilities as our patented substance, B particles. After examination, our R&D department concluded that this has been a modified version of B particles. An independent scientist confirmed this as the Canadian court did. Our legal department wrote a letter to MICO asking them to cease commercialization of the N particles and infringement of our rights. MICO sent back a rude note stating that allegations lacked any grounds. Today, it even challenges the validity of our patent after now having admitted it copied our patent application. Can you imagine? We prove that they infringe our rights and they start threatening us. Totally unheard of. Eine Unverschämtheit. For us, it is clear that they are acted in bad faith.
No matter how often Gigem tried, MICO refused to speak. So we were forced to start an action for patent infringement in the competent court in Canada. And we were awarded, as I said before, $9 million in damages, which included sales made from Canada to the USA, and an injunction preventing future violations.
Okay, thank you. Peter, you've been very patient. What would you like to say?
I really don't know where to start. I mean, commercialization of the N particle does not constitute infringement. The Canadian judge got it all wrong. Our patent lawyers also found new prior art in China that invalidates Gigem's product claim. We designed around the product claim, the process claim, which was public information at the time, and developed something much better than Bind It For All. And that is legal, right? We know that Bind It For All has severe quality issues.
Manon, I'd just like to answer Alexander's allegation that we were unreasonable or that they were the only ones behaving reasonably. I'd just like to, cite to you sections of your letter from your in-house counsel that we received that really did not make us think we had an option to negotiate with you. And I just read it. Quote, within 10 business days, you will send us a 1. Written admission of your unrightful infringement. For every day that you will continue, you will pay us $800,000. Number 2, you demand a list of your customers and copies of all sales and profits to date to allow us to stop all further purchases. And in case you do not accept to do so in 24 hours, we will immediately initiate legal actions, etc., etc. I mean, this for us was not an invitation to meet. We know we have a better product. We frankly saw this as Gigam just wants to prevent us being able to commercialize. So we just couldn't feel we felt we couldn't meet in these circumstances, and I hope you can put yourself in our situation.
Yes, and I have to admit that I did not read the letter of our legal department, for it was sent out. It's Gigam's policy to negotiate from the outset, and I regret the tone of the letter. That said, I need to stress that we only had just heard about Miko's substance and that Luke joined Miko. Somebody must at least got some inspiration from us.
Carl, I appreciate your expression of regret, but we stand on our legal rights here. You know, we manufactured this product on our own from scratch, right? We used publicly available information, and even if it was your own patent information, which is freely available, as you know, and we came up with a different process leading to a new and better product.
But we still need guarantees that Luke Brand is not providing Miko with Gigam's trade secrets.
Okay, now before we discuss Luke Brand, did I understand correctly that B particles and N particles have different properties as a result of their manufacturing processes? Maybe you can tell me more about that.
Yes, our B particle combined several substances, including seemingly incompatible ones, like water and oil. Of course, this is a quite complicated technology. B particles is not entirely stable in all situations, but this is business as usual when introducing a new product.
Carl, what we heard is that it's more than just business as usual. In fact, we hear that you are facing massive R&D challenges. Apparently, your product degrades above 40 degrees Celsius and below 20 degrees Celsius. And frankly, if you try and enter the US or Canadian market with a product that has these problems, you're looking at a massive product liability lawsuit, class action problems.
Well, you hear a lot through the grapevine. This, however, is not why we are here.
I still don't understand the stability issues that you've been talking about. Peter, you said earlier that you see DN particles as an innovation compared to B particles. I'm not a patent expert, but is it possible to get a patent if you improved on a published application to design a similar product?
Yes, we have already received a notice of allowance to our patentation in Canada. B particles is not stable, meaning that it dissolves under extreme temperatures. And the 9-step process used for B particles also prevents it from working with metals. And our N particle product does just that. And by having less steps, we estimate that we can produce this for 15% lower cost than Gigam does.
Okay. How has this dispute affected your business?
Well, as you may imagine, it has been demanding and taking a lot of my energy, as I have spent much time in Canada. I did really like to put this behind me and just concentrate on doing business instead of fighting about legal issues.
Well, you're the one that started litigation, Carl. I mean, Gigam's behavior was totally unnecessary and aggressive. As I earlier said, this lawsuit has cost us substantial damages, and we want to be compensated for that, and for our legal and non-legal expenses to date.
Excuse me? If somebody should get compensated for our legal and non-legal expenses to date, it has to be Gigam.
We will not compensate Gigam for anything. including paying damages for an invalid patent we did not infringe.
Yeah, Manuel, I'd like to adjourn at this stage if possible and have a private meeting with my client. Is that okay with you?
Okay, well, I understand that there is tension, and neither side wants to waste time and resources. And actually, each side views the other side as responsible for the situation they are in. Case. That being said, I think it's a good time now to have a private session with each of you, and so that we can further discuss ways to move this thing forward. Now, Alexandra, would you also like to have some time alone with your client?
No, I think we'd rather move on.
Okay, then if you all agree, I would propose to first have a caucus with Gigan. So Nico can meet privately down in the hallway back here. There is a room where you can meet privately. But before we split up, I would like to ask you to think about the following. Apart from exchanging money, which is an obvious way, what other interests and options do you see? We talked about each party's interest in resolving this dispute. It should be resolved fast. You want to manage publicity and also avoid more expenses and time spent in litigation.
Absolutely.
So that each of you can get back to business, in fact. So when we return in joint session, I would like to explore some of these other interests and options. So, okay, please.
Yeah.
Go ahead.
See you later. Okay, see you later.
Now that we are in caucus, I would like to remind you that everything that we will say now will remain confidential, unless you will explicitly allow me to share it with the other party. That being said, is there anything you did not want to say in their presence, but that's important for me to know in order to help you settle this case?
Miko has taken advantage.
Carl says that he has been blamed for the internal security breach and HR's clumsiness with Luke Brand. He also is upset that apparently the severity of Gigham's quality issues is known to the market, but he is also eager to learn more about Miko's improved formula. Alexandra expresses serious doubts about whether Miko can pay 9 million Canadian dollars and is concerned that they may even go bankrupt. She wants to see the prior art, and she explores the opportunities that Miko's apparently improved formula might bring to Gigam. Alexandra asks the mediator if she thinks some cooperation agreement is possible.
Well, obviously we can raise the prior art issue during joint session. And as far as a possible cooperation is possible, that would also depend on you. Do you have any idea?
Well, we have a large customer who is keen on using B-particles technology for the car coating industry. It's a multi-billion euro market, and I'm intrigued by what I hear about the end particles, as it is true that B-particles does not work well on metal surfaces. This could be a very interesting development for us and for Miko as well.
Yes, even if their products works well, they would never have access to this kind of a client.
Indeed, and it is uncertain if they can pay the $9 million anyway. Instead of spending money on litigation, I did rather invest in new business opportunities.
Okay, let's just assume that Gigam and Miko start to cooperate. What options do you see? Do you speak about a license or cross-licensing agreement, some joint development, or a joint venture distribution agreement, or a form of co-ownership on a new portfolio of IP rights? What do you have in mind?
That's interesting. I hadn't thought of so many options. We could indeed cross-license our patents. They would have no interest in validating our patent, and that would also give us access to their end particles. We are open to discuss this and other options, like a joint venture, but we don't want to propose this to them.
Well, I can discuss several options within, including this one, but you can also do so yourself during the joint session, obviously. I really think you are making excellent progress here. Let me check confidentiality to be sure. I assume that everything I heard now is confidential. But that I can communicate to them that you would like to see their new prior art application, also their application, and that you are willing to explore creative solutions.
Yes, that's fine.
Okay, so what about their or your car coding opportunity? May I mention that to them?
Well, you can say that one of our customers, a leading car company, is interested in using B-particles technology for the car coating industry. And that if N particles work with metal, as well as Peter says, we had to be open to working with Miko.
Very well. Let me now talk to Miko. In the meantime, why don't you think about what information you would wish maybe more to obtain from them, but also what information they may want to receive from you before you can reach a creative deal. Okay?
Yeah, see you later.
Hi, can I join you or do you need some more time?
Please, absolutely.
Okay, so we are now in a caucus, meaning that everything you tell me remains confidential, unless you would explicitly allow me to share it with the other side. So that being said, is there anything that you did not want to say during the joint session that would be helpful for me to know how to settle this case?
Well, it's really not a good time for not a good period for Miko. We really need to generate revenues quickly, and we are in debt. Our future is, of course, fantastic, but the current situation is really tough, and we need to generate money with the N particles ASAP. This case has gotten way too much publicity, and we spent way too much money on litigation costs. And my shareholders really push me to solve this matter and go back to making money for them. If we do not get cash soon, we will be in serious financial trouble.
Manon, as you can appreciate, my client is being particularly honest with you, and we really would like to make sure that none of this information or the seriousness of our financial situation gets to the other side.
Sure, I very much appreciate your and Peter's openness, and please be reassured that everything you told me now will remain confidential.
Okay.
But let's try to prioritize your interests. Okay, well, you've been talking about your cash crunch and your need to generate revenues. Do you think Gigan might be able to help you with it?
Obviously. We need to resolve the lawsuit and third party to it. So, and plus, we know there's no certainty for us of winning an appeal. We're confident, but there is no certainty. In fact, what we were discussing before you came in was more we were looking at the distribution needs for Miko for the future. And we need to have distribution for our N particle products in Asia and in Europe. And we have no presence there, and plus our product is much better than theirs, so they should have an interest. The other thing I'd like to also clarify is that Luke Brand really did not contribute anything to N particles. This was an issue for us when he joined us, and it was written into his contract that he shouldn't bring any confidential information with him because we knew it would contaminate our own efforts. So, but I think it's blocking them from trusting us. And so, they're a huge company. They're extremely aggressive. And I guess we need to know that we can trust them if we're going to be working with them.
Okay, so you want to be able to freely commercialize the N particles, and you think that Gigan can help you with this. At the other hand, you also see an issue of trust. Let me ask you a hypothetical question. Would you consider working with Gigan, maybe on a pilot project?
Well, yes. I mean, Luke Brand says that Carl is a pretty solid and trustworthy guy, although he seems pretty arrogant to me. But I have no idea about what sort of corporation would make sense, and would they treat us fairly? I mean, they're way bigger than we are. Also, a pilot project sounds nice, but I cannot think of anything we have to offer them to work on.
And Manuel, isn't the question the other way around? I mean, they think we stole their trade secrets. So how likely are they to want to do a project with us at this stage? I mean, isn't it naive? I'm willing to try. It makes sense to try, but we can't even raise this issue ourselves. We don't look like we're desperate.
Mm-hmm. Well, Chris, I understand that you don't want to look too eager to cut the deal, but yes, Gigam has authorized me to inform you that it is open to explore a very broad range of creative solutions. And depending on whether the end particles can work with metals, one idea they allowed me to share with you is that one of their leading customers wants to use this B technology for the car coating industry. It's a big market. And if end particles performs as well as you were saying, and I believe you have a great product, Gigam may be interested in working with you on a pilot project.
Wow. Who would have thought?
Yeah.
Okay, so is there anything else you wanted to tell me during this caucus?
No, we need to find out more about that.
Yes.
Okay, so may I suggest then that we go back to joint session and then explore this and other options together?
Sure.
Yeah, sure. That sounds great. Yeah.
Hi. Are you ready to reconvene in joint session?
Yes, we are.
Okay, thank you.
So it's basically like a miraculously good outcome for a mediation, right? So these parties came in there, this intellectual property dispute, and one of them was going to have to pay $9 million to Miko was going to pay $9 million to Gigam for infringing its patent, according to the lower court. But Miko says we don't owe you a penny, and we're going to get that overturned on appeal. And you owe us $1 million for having stolen our customers, and so on. So they're confronting this horribly expensive litigation path. And then by the end of it, they are going to be business partners and best buddies. And basically, the smaller company, Miko, is going to provide its superior particle to the bigger company, Gigam, and then Gigam is there's going to be a licensing deal where Gigam will provide that to its customers, and they're both going to make millions of dollars together. That, of course, is the best conceivable outcome for mediation, and it's sort of like the facilitative dream, where you turn parties from adversaries into allies by using a mediation process that uncovers these interests, these shared interests they have, and uncovers how they actually can meet each other's needs, right? Because Miko, the small Ontario company, has a superior product, and Gigam has the big market share and relations with all the customers, and if they get together, it's a match made in heaven. So, this is not what you should expect to happen in any real mediation. This is, a promotional video for this mediation company that's trying to sell people and train people on the idea of mediation. But it is kind of a dynamic, dramatic illustration of how this can work when it actually does work. So let's think about what the mediator was doing. So, evaluative mediators, as we said, the evaluation is evaluating the legal merits of the case, right, and making predictions about. And as I'm saying all this, feel free to change your vote on this poll if you assume you can still do that. So evaluative mediators evaluate the legal position, make predictions about what will happen in court. Evaluative mediators typically have legal expertise, right? So expertise about the specific legal issue, right? And here it's intellectual property law, patents law. And evaluative mediators may also have knowledge about the industry, the area, right? So know about industrial coatings and the nature of the business that these people are engaged in. So fortunately, as I say that, I see people gradually shifting toward the facilitative answer to this question, because this was the epitome of a facilitative mediation, right? Her role did not involve any evaluation, did not involve any prediction of legal outcomes. It involved facilitating communication. So, so who can tell us a little bit more about what she did? Because I think these parties, like if it had just been the lawyers and their clients in that room, what would they have been able or unable to do without her? Yes, revealing the confidential information, right? They each of them were willing to say things to her that they would not have said to each other's faces. And so that's a key role that a mediator can play. It's like kind of a selective information conduit, where there's certain things that the mediator will know without revealing, but then the mediator can kind of make proposals or suggestions that are informed by what they've been told confidentially. And they can also pass information selectively, like reveal only what they've been told to reveal. People are saying that building consensus, able to diffuse the tension and redirect them towards a common ground. Tried to hear what everyone was saying. And there's also the agenda keeping is very helpful, right? Like just that writing down a list of what we're going to talk about can help build trust and communication insofar as parties, if you see your concern that you really want to talk about on a list of things that are going to be discussed eventually, then that makes you more receptive to listening to the other party while you're at a different item on the agenda, because it just creates confidence in people that their concerns are going to have time to be discussed. Okay, so that's good, and she was sort of able to kind of produce that turning point where they started talking about it. It also illustrates positions versus interest, right? The positions were, what information did Luke Brand have? Was there prior art that renders your patent invalid? To what extent did Miko's particle steal the intellectual property of Gigem's? Right, those were all positions. The interests that they got at only in the caucus sessions. Right, caucus, you remember, is where the mediator is in a room with only one side. But the interests, right, where Gigem was saying, well, we know our particle is not that great. It doesn't work in lots of contexts. And we regret the tone we took in our letter. And then Miko, for its part, is saying, look, our company's on the ropes. We can't afford this. We don't have access to the customers. So those interests, again, are the things, are where the overlap was found, right? And where the potential for negotiated resolution was found. The common issues and the shared interest that they have. Okay, so I think that's all I wanted to say about it. Take it with a grain of salt. It's sort of facilitated mediation on its very best day, but it does illustrate some of the things that can really make this work. Also, the fact that as they go forward, a lot of those legal issues will become irrelevant, right? Like, what did Luke Brand know? What did he tell them? Who cares? Let's go make some money together. We got something that can unite us. Any questions or comments on this? Okay. So for those watching at home, feel free to click the URL if you want to watch it on YouTube instead of through this video. Barring that, we will reconvene on Tuesday and have a terrific weekend, and I'll see you then.